Yes, good morning, students. This is Pahuja Law Academy. Running for the last several years and has got the distinction of producing a number of successful candidates in almost all the state judicial services examinations. Keeping in view the variety of questions that are frequently asked in judicial officer examination, we have compiled, certain items in a number of fields which will be beneficial for all the students, whatsoever the preferred states are there. Myself is Mr. Vijay Kumar Sinha. I am the senior faculty member of Pahuja Law Academy, and for the last several years I am teaching students a number of areas which are relevant for this examination. I am teaching constitutional law, both objective and subjective point of view, teaching jurisprudence, international law, administrative law, and above all, for the last several years, every weekend, Friday, Saturday and Sunday, there is a general awareness program which is being conducted by me for the last several years, you see. If I get the opportunity, I'll tell you the entire, program, general awareness program, on the board, you see. Today, I have chosen a very important topic for all of you, and this topic is titled as Right to Freedom of Religion, which is currently also, a hot topic of discussion among the academic circles, you see. Right to freedom of religion, right to freedom of religion, you see. Right to freedom of religion is a part of, as you all know, is a part of Part 3rd of the Indian Constitution. It's a part of Part 3rd of the Indian Constitution, that is fundamental rights. Fundamental rights, in one sentence, there is a unique characteristics or element of fundamental rights as explained in Part 3rd of the Indian Constitution. This unique characteristic is, defined as that Part 3rd, in one sentence, Part 3rd is a fine balance, you see. Part 3rd is a fine balance between individual liberty on the one hand, and social control on the other, you see. This line, balance between individual liberty on the one hand and social control on the other, this balance, this characteristic This characteristic, in simple words, this characteristics in simple words suggest that the citizens and the non-citizens also, the citizens and the non-citizens have been provided with certain rights. Certain rights, in part third of the Indian Constitution, you see. But at the same time, these rights are not absolute, you see. These rights are not absolute. It is subject to, as you all know, it is subject to, reasonable restrictions as propounded in, subject to reasonable restriction as propounded in Article 19(2) to 6. You see. Right to freedom of religion is not an exception. And this is what I am trying to say. This part of part third, right to freedom of religion, is not an exception. It is also subject to certain restrictions, certain general restriction and certain particular restrictions, you see. India is a multi-religious country. India is a multi-religious country. India is a land of diversities. And religion in India is a matter of faith, is a matter of faith with individuals and communities. Now, this right to freedom of religion has its base. It has its base, you see. इसका एक आधार है, you see. This right to freedom of religion has its base, and the base is to be traced in the philosophy of the Indian Constitution as propounded in the preambular philosophy, as propounded in the preamble to the Constitution of India. Philosophy, there are certain inherent philosophies in the preamble to the Constitution of India. And one philosophy, constitute that we the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, you see. Sovereign, socialist, secular, democratic republic, you see. Secular word, although was added in the preamble to the Constitution of India by 42nd Amendment, certain words were added that you all know. Secular word was added in the preamble to the Constitution of India by 42nd Amendment, you see. '76 came into force in 77, of January 77 came into force. But much before this addition, you see, this is what I am trying to say. Much before this addition, in the goals of the nation, because the goals of the nation is also provided in the preambular philosophy, you see. And the goals of the nation is provided to secure to all. It starts from to secure to all its citizens justice, social, economic and political. And then there is a line, liberty of thought. This is the punchline, you see. Liberty of thought, expression, belief, faith and worship, you see. So much before the addition of the word secular in the preamble to the Constitution of India, preamble to the Constitution of India, I mean, the goals of the nation was defined in liberty of thought, expression, belief, faith and worship. So, the basic secular philosophy already existed from much before use. Existed from much before. So, the right to freedom of religion, now you just connect it. There is a link between the two. So, the right to freedom of religion. So, the right to freedom of religion and has a close ties, you see, has a close link, has a close link with liberty, this line, liberty of thought, expression, belief, faith and worship, as explained, I mean, in the preambular philosophies. The base of, the philosophical base of right to freedom of religion is to be traced in, I mean, liberty of thought, expression, belief, faith and worship use. Faith and worship. So, can see faith and worship. This is the nature of, this is the nature of, this is the type of, this is the nature of the Indian political system. This is the nature of the Indian political system. Now, if you start with the right to freedom of religion, if you start with the right to freedom of religion in this connection, right to freedom of religion in this connection, I mean, the whole right to freedom of religion is categorized in, I mean, 4 important provisions. First is Article 25. 25 is titled as freedom of conscience, free profession, practice and propagation of religion. Article 25 consists of, I mean, twofold important provisions, you see. This is 25 clause 1 and 25 clause 2 A and B. This 25 clause 1 and 25 2 clause A and B. Then we have the next title, that is 26, and this provision 26, I mean, is titled as freedom to manage religious affairs. Freedom to manage religious affairs. This is followed by Article 27, you see. This is followed by Article 27 of the Indian Constitution. Freedom, this is freedom not to pay taxes. This is freedom not to pay taxes for religious promotion, And the last one is Article 28. Article 28, and freedom as to attendance. I mean, this is titled as freedom as to attendance at religious instruction, at religious instruction or religious worship in certain educational institution. So this is the, I mean, this is the, I mean, the domain of, this is the domain of, this is the, I mean, this is the domain of, this is the domain of relevant provisions in connection with this right to freedom of religion, connection with this right to freedom of religion. Now, if you come to, I mean, the most important is Article 25. Now, if you come to Article 25, I mean, the first, if you come to Article 25, you see, Article 25, first of all, Article 25 and precisely comprise four, first of all, it precisely comprise four important parts, you see, precisely comprise four important parts, you see, four important parts, you see, the four important parts, you see. The first one is right to freedom of conscience, you see. This is the first one, you see. Right to freedom of conscience. Right to freedom of conscience. Actually, this line refers to, I mean, the inner freedom of a person. Inner freedom of a person. Inner freedom of a person to mold his relationship with God in whatever manner he likes, you see. To mold his relationship with God. This is the inner freedom, you see, in whatever manner he likes, you see. This is right to freedom of conscience. This is right to freedom of conscience. This is right to freedom of conscience. So this is the, when you start with the article, I mean, the first important point is, I mean, it consists of four important parts, and this is the first part, you see, right to, I mean, right to freedom of conscience. Second part is right to profess. देखिए है ना, in course of this discussion, I would also like to, I mean, I would also like to suggest one thing, that in judicial officer examination that you are going to face, I mean, in near future, you are advised, you are sincerely advised that three things are very important, you see. Whatever topics you are studying, say for the moment at the moment I am studying right to freedom of religion, but there are some three important general suggestion, advice for all of you. First is that you should understand the basics of the provision, you see. Basics of the provision. Basics of the provisions along with the basics of the concept, you see. Competition is actually a game of fundamentals, you see. Competition is actually a game of fundamentals. So this is my first advice to all of you. The second advice in this connection, the second advice in this connection, I mean, which I would like to, I mean, tell all of you, the second advice in this connection is that sorry, that you must have a planning on the structure of the topic. You must have a planning of the entire structure of the topic, you see. जैसे मैंने राइट टू फ्रीडम ऑफ रिलीजन शुरू किया, तो पहले मैंने डिस्कस किया द फिलोसफिकल बेस ऑफ the philosophical base of right to freedom of religion in preambular philosophy. So you must have a structure of the topic, must have a planning of the structure of the topic. तो पहले एडवाइस में you have to keep the bare act with yourself always. You have to understand the basic concept. और दूसरे एडवाइस में you must have a planning of the length and breadth of the topic you see concerned. उसका प्लानिंग, एक स्ट्रक्चरल प्लानिंग इज रिक्वायर्ड यू सी. A structural planning is required on the board, you see. A structural planning is required on the board, you see. And the third advice is in this connection that wherever it is required, you see, wherever it is required, you are expected to connect the constitutional topics with current update. Wherever it is required, you are required to connect this, these topics with current updates. जैसे उदाहरण के तौर पर, नाउ लेट अस टेक एन एग्जांपल यू सी. There was a case in 2022. There was a case in 2022. The case was Aishat Saifa versus State of Karnataka. Might be knowing also. Aishat Saifa versus State of Karnataka, 2022. Now in this case, it was a two-judge bench decision. The Supreme Court, in this case, it was a split judgment on hijab, you see. It was a split judgment on hijab, you see. Hijab, today, it has been, and today also, state of Karnataka and Rajasthan, it has been a controversial issue. So the question, in this connection automatically arises, you see. The question automatically arises, you see. The question arises that what is the constitutional status of this, controversial issue, hijab? Is it covered by the right to freedom of religion? This has to be tested. This has to be tested in the provision between the lines, you see. Now, if you see Article 25, Clause 1, on the one hand, and Article 25, Clause 2A and B, there are two kinds of restrictions already explained, you see. In 25 Clause 1, it is categorically stated that this freedom of conscience and free profession, practice and propagation of religion is subject to two things. It is clearly, clearly stated, subject to two things. Subject to number one is public order, number two is morality and health, you see. एक तो साफ शब्दों में लिखा हुआ है that this 25, clause 1, categorically states that this right is subject to, particular restriction like public order, health and morality. And it is also written that it is subject to other provisions of this part. Other provisions of this part means the other provisions of part 3rd. Other provisions of part 3rd. Now here, what we mean when we use the word other provisions of part 3rd, we mean the reasonable restrictions as is stated or expounded in, the reasonable restriction as is stated in Article 19(2) to 6. Article 19(2) to 6, as a matter of fact, Article 19(2) to 6, as a matter of fact, talks about 19(2) to 6 talks about, the reasonable restrictions on the 6 freedoms as is stated in Article 19. So there are, if you see, this right to free, what I am trying to say, that this right to freedom of religion, you see, is not absolute. Is not absolute. Further, you see Article 25 2A and B. Further, if you see Article 25 2A and B, so 25 2A and B, this provision empowers the state. This provision empowers the state, you see. This provision empowers the state. This provision empowers the state, and empowers the state के नीचे आप A और B दो चीज को नोट करेंगे या दो चीज समझेंगे. empowers the state to regulate or restrict, you see, to regulate or restrict any economic, financial, any economic, financial and political, any economic, financial, political and or other secular activity. State is empowered to regulate. That means state is empowered to regulate secular activity. तो मान लिया, फर्ज कीजिए, मान लिया अभी जैसे आप जरा देखिए, जैसे उत्तराखंड इज द फर्स्ट स्टेट to have a legislative declaration on uniform civil code, you see, in India. Now this is step by the state, this is step by the Uttarakhand government is a secular step, you see, is a secular step as directed in Article 44 of the Indian Constitution, you see. The state is empowered. Article 25 2A and B says the state is empowered to regulate or restrict any economic, financial, political or secular activity which may be associated with any religious practice, you see, which may be associated with any religious practice, you see, which may be associated with any religious practice, you see. So, the status of, introducing a dress code. A dress code is, notified by the state government. This is a secular step. So what we have to take into account, that this right to freedom of religion, you see, what we have to take into account, that this right to freedom of religion, you see, this right to freedom of religion is not absolute. It's not an absolute right, you see. The state is empowered. तो यही मैंने ए में बताया, और बी में the state is empowered to provide for social welfare and reform. The state is also empowered to provide for social welfare and reform, and throw open Hindu religious institution of public character to all classes and sections of Hindu. So this philosophy of secularism, this is what I am trying to say. So this philosophy of secularism, you see, is translated, philosophy of secularism is translated into a number of constitutional provisions, you see. It's translated into a number of constitutional provisions, you see. Number of constitutional. That's why it has been translated into Article 14, 15, 16, 25 to 28, 29, 30, 325 and 44. This is translated into 25 and 44. So these, provisions which I just now, told you, these provisions actually calls for the establishment of a secular polity, calls for the establishment of a secular polity or secular state. So sometimes the question also emerges, you see. Sometimes the question emerges, you see. What are the three basic characteristics of secularism, you see? What are the three basic characteristics of secularism? So there are three basic characteristics of secular state. One is that the state will not have its own religion. The state will not have its own religion. The state will not have its own religion. This is number one. The second is that the state will be neutral in religious matter. Second is state will be neutral in religious matters. And the third is respect for all religion, that is Sarva Dharma Sambhav. These are the three characteristics. But sometimes the question is asked like this, a subjective question is asked like this. Now please, you can note it down, the pattern of question in subjective, you see. Sometimes the question is asked sometimes the question is asked that India is a secular state. India is a secular state. India is a secular state, but not a secular society. India is a secular state. When I say India is a secular state, I mean that the three characteristics that bears the basic philosophy of secularism exist in the constitutional scheme, exist in the constitutional scheme of our countries, exist in the constitutional scheme of our countries. But the society is not secular. But the society is not secular, you see. But the society is not secular, you see. यानी कहने का मेरा मतलब है that there are certain practices in the society, and out of which we arrive at this conclusion that the society is not secular in India. जैसे उदाहरण के तौर पर आप देखिएगा पॉलिसी ऑफ अपीजमेंट, policy of appeasement of the minority sections, policy of appeasement of the minority section. The second is the politics of religion and religion of politics, the politics of religion and religion of politics, you see. The third is existence of fundamentalist organizations, you see. Existence of, जैसे जमायते इस्लामी, बजरंग दल, I mean existence of fundamentalist organization, existence of, I mean fundamentalist, I mean leaders. Society is not secular. Society is not secular. तो जब क्वेश्चन आई मीन इस सेक्शन से रिलेटेड, जब क्वेश्चन इस तरह का क्वेश्चन आपसे पूछता है, आई मीन व्हेनेवर आई मीन अ क्वेश्चन इज आस्क्ड, यू सी, तो एक बड़ा इंपॉर्टेंट थॉट प्रोवोकिंग आई मीन क्वेश्चन है that India is a secular state but not a secular society, you see. Now, it is true, it is now true and it is now clear, it is now clear that there is no, I mean, controversy whether we have a secular state or not, but there is a controversy regarding whether the society is secular or not. That much is very clear, you see. तो कहने का मेरा मतलब है ना, that secularism therefore is a part of, secularism therefore is a part of, I mean the basic structure of the constitution, is a part of the basic structure of the constitution, you see. And for the first time, this was stated in, I mean, Keshwanand Bharti case 1973, secularism as the basic structure of the Indian constitution, you see. And secondly, also in S.R. Bommai versus, and secondly also S.R. Bommai versus Union of India, you see. S.R. Bommai versus Union of India 1994, and the Supreme Court observed, it is categorically observed, you see. The Supreme Court categorically observed that secularism is the basic feature of the Indian constitution, is the basic feature of the Indian constitution. And so in Aruna Roy case, the Supreme Court is stated, what the Supreme Court is stated has to be taken into account, you see. Supreme Court is stated that the study of religion in school, is not against secular philosophy, is not against secular philosophy, is not against secular philosophy. It is susceptible to, positive meaning, it is susceptible to positive meaning, that is and developing understanding, is susceptible to positive meaning, that is developing understanding and respect towards, developing understanding and respect towards, and respect towards different religion, and respect towards different religion, you see, and respect towards different religion, and respect towards different religion, you see, and respect towards different religion. Now in this connection, and in this connection, in a number of cases, you see, in this connection, in a number of cases, you see, the number of cases, you see, in the number of cases, and the Supreme Court has earmarked, you see, earmark the division between, earmark the division between essential religious practice and non-essential religious practice, you see. Essential religious practice and non-essential religious practice, you see. And this is known as, an essential religious practice is known as the doctrine of essentiality, you see. The doctrine of essentiality, the doctrine of essentiality, and this doctrine for the first time was, invented by, this was invented by the 7-judge bench, you see. For the first time, this was invented by the 7-judge bench, you see. The 7-judge bench in the Sri Sirur Mutt case. Sri Sirur Mutt case, AIR 1954, wherein AIR 1954, wherein the Supreme Court held that the term religion will cover, that the term religion will cover, that the term religion will cover all rituals and practices, all rituals and practices integral to religion, all rituals and practices integral to religion, and took upon itself, और अपने ऊपर सुप्रीम कोर्ट ने जिम्मेदारी ली, and it took upon itself the responsibility, of determining the essential and non-essential practices of religion. Essential and non-essential practices of religion, you see. Essential and non-essential practices. So there are a number of cases. And there are a number of cases in these connections. And when you start with the basic subject matter is the philosophy of secularism. The basic subject matter, this is to start with for the sake of, students' basic knowledge, you see. And I have stated this topic at length, you see. And baad mein, you see, in the normal class, you will be hearing the whole gamut of constitutional law, in this connection, you see. You have to understand right to freedom of religion in the basic constitutional scheme as provided in the basic philosophy in the preamble to the Constitution.